Section 45. Following the European Court of Human Rights in VCL and AN versus the UK, it is incumbent upon policing to be alert to the particular circumstances or situations where someone suspected of committing a criminal offence might also be a victim of trafficking or slavery. We must not rely on the suspect or their legal representative to raise this. Therefore, when dealing with someone for a criminal offence, ask yourself the question: could this person have been exploited by another to commit this offence? If there's any possibility that they have, we must consider Section 45 of the Modern Slavery Act 2015. Under the Modern Slavery Act, Section 45 refers to a statutory defence. This defence was introduced to encourage genuine victims of modern slavery to come forward without the fear of being prosecuted for the offences that they may have been forced to commit as the result of their exploitation. The defence is most commonly seen in drugs cases such as county lines drug dealing and cannabis grows. However, it may also apply to suspects for other eligible offences such as shoplifting, prostitution and begging. The defence does not cover more serious crimes such as rape, murder and modern slavery itself, and a comprehensive list of these non-applicable offences can be found in Schedule 4 of the Act. It's therefore worth noting that the defence cannot be used by alpha victims, those who were themselves trafficking victims but then transitioned to become involved in the trafficking of other vulnerable victims. However, the CPS may still decide not to prosecute in these cases by considering duress or not being in the public interest. As in any defence, it can and will be sought to be abused by suspects to try and get away with their offending. As investigators, it's therefore our job and responsibility to prove or negate, as best we can, this defence at the earliest opportunity. We need to investigate this as we would any other defence for any other crime type. When a suspect has raised the defence, or police identify they may be entitled to the defence, then the legal burden of proof falls to the prosecution to prove beyond reasonable doubt that they were not a victim of trafficking, that they were not compelled to commit the offence as a result of the exploitation, that a reasonable person with the same characteristics as them, in the same circumstances, would not have committed the offence. A child does not need to be compelled, therefore there is no need to prove they have. This is a complex set of factors to consider which can be subjective. Therefore, it's likely that the CPS will want to review this information, and this may even be taken to court for a decision if the defence applies. There are already numerous examples of cases getting to court and hours of police and prosecutors' work being wasted when a member of the Youth Offending Services, a court official, or even a judge recognises potential trafficking and puts the whole case on hold until the Section 45 defence can be resolved. As we cannot assume that legal representatives will pick up on the statutory defence, and if they don't, and we fail to close it off, then we are at best wasting a lot of police and prosecution time, and at worst failing in our legal duty to identify and to protect victims of modern slavery. We know that there are many factors that will prevent someone who has been trafficked or exploited from identifying themselves as a victim, and therefore raising the defence themselves. For example, shame, physical threats, debt bondage, and mistrust of authorities. Look at the whole picture and not necessarily just what the suspect is saying. If you decide there is a necessity to arrest or voluntarily interview, in circumstances where the Section 45 defence could apply, you must consider negating the Section 45 defence as part of your interview plan and wider investigation. Your interview should cover all points to prove that could be relevant to the Section 45 defence, in the same way that you would cover the points to prove when a defence of duress was being raised. Your questions should cover their vulnerability, how were they recruited, and what control measures were used. You would need to agree what the defendant admits to doing under coercion in order to fairly assess whether the Section 45 defence applies. That way, all aspects of your points to prove for the original offence would be covered in the interview, and this would not need repeating should the Section 45 defence not hold up. If inquiries can be completed immediately following interview to prove or negate the statutory defence, then they should be actioned while the detainee is in custody. If you are considering the Section 45 defence, but inquiries cannot be finalised there and then, an option would be to give consideration to release the person under investigation, RUID'd. Other alternatives include bail with appropriate conditions attached to this. Important: if a person raises a Section 45 defence, it's not necessarily a get-out-of-jail card for them in terms of the reason not to defer a charge or charges, and seek a remand in custody. If you suspect that the individual is a victim of trafficking, you should record a modern slavery crime and commence an investigation. This may run parallel with the criminal investigation until we can prove or negate the trafficking and all the Section 45 defence. The national referral mechanism should be discussed with the individual and a referral made for those under 18 and with consent for those over 18. Remember, you are not simply switching from a suspect to a victim focus if the Section 45 defence is raised, but considering all of the information that has been presented, and thus be aware that the Section 45 defence can be raised at any point. Plus, a positive CG decision from the NRM for someone the police consider to be a suspect does not mean that the individual won't be prosecuted. The decision can still be made to continue with the prosecution. There is a need to demonstrate why you disagree with the SCA decision and provide evidence to rebut the use of the Section 45 defence.